It's a real pleasure to be here today. One of the reasons is I get to moonlight to hear and actually hear a criminal case. I never get to do that. The other reason that it's going to be great is to see the quality of the mooters who are presenting this afternoon. And I've been told that the quality of the mooting over the last couple of days has just been outstanding. So I'm really looking forward to hear the finalists here, just as you are as well. And I want to thank all of you for being here as well. I know a lot of you mooted in the competition, and I know how hard a lot of you worked to be able to present. And last night I talked about the benefits of mooting. I want to thank all the people who are here to support their teams and to watch what's happening this afternoon. And I see parents and even some grandparents here as well to support their family. And that's always nice to see. It's always nice to see your kids in this type of situation. I can tell you my son went to Osgoode 8 years ago. My wife's a lawyer, I was a judge, and I can tell all the undergraduate students, it takes a while for your parents to start to take you seriously. You know, my son would come home, and I can remember him telling my wife and I about some spousal support principle. And we weren't really listening to him. We were just thinking, oh, isn't that cute? He's talking about spousal support. And so it took a while for us to take him seriously, and your parents get to see you in a different light when they come to this type of program. When you watch the moot this afternoon, the judges are going to be looking for certain things, and you should be looking for certain things. We're going to be looking at the sense of organization. We're going to look at mastery of facts. We're going to be looking at how well the mooters can respond to questions, how persuasive they can be, how responsive they can be. And we're going to be judging all those qualities. We're going to be judging their demeanor. We're going to be judging their poise. I always said that, you know, when I was an advocate, that unless I could convince the judge to buy a timeshare by the end of my presentation, I wasn't doing my job. So that's the type of thing that we're going to be looking at this afternoon. And so I'm going to get off the stage now, and we're going to bring in the judges soon, and we're going to focus the spotlight on the people who deserve it, who are your finalists. So I'll be with you in a few minutes. Okay, so let's start with the appellants.
May I proceed? Good afternoon, Your Honors. My name is Sarah Tyler, counsel for the appellant in this matter, Mr. Alex. My co-counsel is Harshita Iyer. The appellant has 3 submissions. First, I will submit that the decision in Rilling is flawed, necessitating review of the interpretation of Section 258 of the Criminal Code. I will then submit that the need to correct the error is not insubstantial. My co-counsel will then submit that a correct statutory interpretation includes lawfulness of the demand as a precondition to employing an evidentiary shortcut and the policy implications of such an interpretation. Your Honors, before I proceed, would you like a brief recitation of the facts?
I don't think that's necessary. Go ahead.
Thank you. To begin, when the court came to its decision in Rilling that lawfulness of the demand was not a precondition for a Section 258 evidentiary shortcut, rather than relying on a rigorous statutory interpretation, they relied on precedent set forth in Ray. The issue with this, the appellant submits, is that Ray handled admissibility under common law, specifically holding that relevant evidence, although unlawfully obtained, may be nonetheless admissible. Applying this to an evidentiary shortcut case under the Criminal Code, as was the case in Rilling, would be an inappropriate conflation of criminal code and common law principles. And further, because the court relied primarily on this Ray precedent rather than a thorough statutory interpretation, the court effectively circumvented a full interpretation, as Ray itself did not examine evidentiary shortcuts, and Rilling then did not either. Further, because the case of Rilling predates the decision in Rizzo and Rizzo Shoes Limited, establishing the modern form of statutory interpretation, not only did Section 258 not receive a thorough interpretation under 1976's standards, but has never received any modern interpretation at all. Your Honors, considering this, the appellant would direct the court to the principle found in Canada and Craig, that if we are to consider changing precedent, we must balance the benefit of certainty with the need to correct the error.
Counsel, when you talk about Rilling, you're talking about a case that predates the charter. And quite frankly, in this case, your client, Mr. Alex, would have the charter to pursue as an avenue for a remedy, namely Section 8 and Section 24(2). What would, regardless of what we do with the statutory interpretation, what would overturning Rilling do when, in the grand scheme of things, the remedy that you're seeking for your client would likely be an acquittal, which you would find under 24(2), as opposed to a statutory interpretation where you'd like us to impute lawful demand?
Your Honor, the appellant submits that there is, in fact, a practical difference that is contingent on whether we count lawfulness as a precondition as well and not just a potential separate charter claim. For example, Your Honors, the credibility of the state is called into question when we have an officer, an actor of the state, already making an unlawful demand, and therefore this would suggest the usefulness of an extra protection, such as having two in-person witnesses, which the defense could cross-examine at trial to prove their case.
Could these two witnesses speak to whether or not the officer had reasonable grounds?
No, Your Honor. However, that does not make this of no practical effect. Your Honors, to directly rebut one of the preconditions under Section 258, C and G, those relating to accuracy, the defendant and accused would have to rely primarily on his or her own testimony as to whether the breathalyzer test was malfunctioning or else was improperly administered. Now, it is far less likely that an average person, such as the accused, would recognize and then be able to prove an improperly administered test that must be administered by a qualified technician than that the accused could suspect an unlawfully made demand, bring that issue to a judge's evaluation, and then perhaps have the evidentiary shortcut excluded that way.
So in this particular case, are you looking to set aside the shortcut because you think that the exam was flawed, or the manner in which the exam was conducted was flawed because of the police?
Your Honor, the appellant would submit that this refers more to the principle. In this specific case, the record does not explicitly show whether there would be a difference in accuracy. However, the appellant would submit that there is a practical difference in whether lawfulness of the demand is included as a precondition that must be recognized to maintain the integrity of this provision. If the appellant is unable to, at the outset, attack one of the preconditions of accuracy, but suspects an unlawful demand and finds it proven, we have a state actor in the police department who has already acted unreliably. That suggests a possibility that other actors in the department, perhaps administering the breathalyzer, may not have, and giving the appellant this opportunity to further explore the issue of accuracy through in-person witnesses and cross-examination.
Do you think it's unfair in some way, though, that the accuracy of the breathalyzer and the administration of the breathalyzer as a technical instrument is only really open under your submission for challenge and review if it is the result of an unlawful demand? All of the issues you're raising concerning the possibility of that a breathalyzer was malfunctioning, that it hadn't been properly maintained, and the ability to uncover same through cross-examination, under the statute is not available to somebody who's tested pursuant to an unlawful demand, pursuant to a lawful demand. So should we be worried about the fact that if we take your definition, only an individual who receives an unlawful demand can mount that kind of a challenge?
Your Honor, the appellant is looking for a reasonable balance of protections to the accused and the concerns that we do anticipate our friends will raise. When an accused is faced with concerns perhaps about the accuracy, any accused, regardless of whether the demand was found lawful or unlawful, can attempt to rebut those preconditions directly without the witnesses. The appellant would submit that this extra opportunity to explore the accuracy is only necessary when unreliable actions by a state actor have already brought the credibility of the Crown into question. And that this extra protection in this circumstance is reasonable and perhaps even necessary for those average accused who are not able to recognize a technical impropriety at the outset during their breathalyzer test.
But isn't this a case of just one bad apple? But what you're telling us is the whole tree has gone rotten by the fact that the police officer did something wrong.
Your Honor, I am not suggesting that we know for a fact that due to one reliable actor, everyone in the department has behaved unreliably, but that it does raise a suspicion that would merit a second level of protection. That is, the opportunity for the accused to investigate the possibility that the rest of the department behaved unreliably. Not to know from the outset, then, that they did, but the opportunity to explore that in court via 2 live witnesses attesting to accuracy.
But doesn't that directly go against the whole purpose of this shortcut in the first place? I mean, as my colleague mentioned, that it could be one bad apple that acted inappropriately with an unlawful demand, but the certificate is deemed to be reliable, and that's what the legislature has determined, and they're trying, my understanding is the purpose is to streamline these, to get these cases through the courts quickly. And so what is your response to that in terms of how the administration of justice is going to fall into disrepute if there's a lot of delays and we can't administer these cases?
Your Honor, the delays would still be limited to those who show that the precondition of a lawful demand was not met. The 2 witnesses would not need to be brought in every case, only in a case where one of the preconditions, including, as we would submit, lawfulness of the demand, is not satisfied. And additionally, while this may cause some delays, we do concede in those cases where unlawfulness is shown to exist. Those delays and inconveniences to the Crown must be balanced with protections to the accused. And this minor protection of an opportunity to re-examine the accuracy when the Crown has already behaved unreliably is, the appellant submits, a reasonable step to ensure that the accused has a full opportunity to fairly contest any evidence presented against them.
But counsel, isn't the purpose of the precondition in 258 just to deal with the reliability of the evidence, not its admission? Isn't the core of your argument that it shouldn't be admitted and it's not a reliability argument?
Your Honor, I see that my time is almost elapsed.
You can take an extra minute and answer. Go ahead.
Your Honor, this is, as far as the connection of the preconditions under C and G of 258, specifically pertaining to accuracy and reliability, and 254 containing lawfulness connections, my co-counsel will submit how a reading of the words pursuant to would imply that the conditions set under 254.3 would also have to be met first. Additionally, as to the notion of contesting reliability through lawfulness, I would clarify that by getting the chance to cross-examine those witnesses, once again, the appellant does not submit our cross-examining them to weigh in on the lawfulness of the demand, just the accuracy, as a second opportunity to review the reliability of that evidence when the Crown has already behaved unreliably in a different regard, the regard of lawfulness.
Thank you very much.
Thank you.
Good afternoon, Your Honors, and good afternoon to my friends. My name is Harshita Iyer, and I will be concluding the submissions on behalf of the appellant, Mr. Alex. Your Honors, I submit that a correct statutory interpretation under the modern framework established in Rizzo and Rizzo Shoes Limited demonstrates that a lawful demand is in fact a precondition to use of the presumptive shortcuts laid out in Section 258. I will then evaluate some of the policy implications of our position, namely the effects on delay and other provisions in the section. Your Honor, a modern statutory interpretation calls to balance Parliament's intention with the objective and the scheme of the Act and a plain and purposive reading of the text in question. If I could actually direct your attention to Section 258 itself, in referring to the phrase pursuant to a demand, Justice Rao of the dissent defines pursuant to as conforming to or consequent to a demand. If the reasonable grounds referred to in Section 254(3) are not a precondition to the use of the evidentiary shortcut in Section 258, it would suggest that the phrase pursuant to a demand have no legal meaning, and surely this cannot be the case. Furthermore, Your Honors, there are other preconditions that are established in Section 254(3). If we take the precondition of lawfulness to not apply, it would also suggest that the precondition that the demand is made by a peace officer or that the demand is made at a time as soon as practicable to the offense also do not apply, and surely these would in fact influence the reliability of the Crown's evidence that is found in the shortcut. Therefore, it is not within the Court's prerogative to simply draw lines where and when Parliament meant certain terms. It has to do with statutory interpretation that takes the plain text reading in accordance with the whole intention of the section.
Yes, now counsel, go ahead. Okay, counsel, if we're doing a plain interpretation and we're looking at Section 258, couldn't the legislature have just put it into 258? Wouldn't that be the most plain reading of the legislation?
Your Honor, we submit that this could have been an option to Parliament. However, we have noticed throughout statutes that Parliament takes an intention to avoid being redundant. And because Section 258 directly refers to Section 254, where the lawful demand is clearly stated, it is our submission that the pursuant phrase intends to import all three of those conditions.
What can you say to other sections where Parliament has actually used those words?
Respectfully, Your Honor, such an example of a provision would be, for example, Section 127. And 127 does not connect to other offenses. It is simply an offense in its own context, and therefore that lawful demand was intentionally stated to ensure that lawful demand is followed in that case. But because this is a connection offense where it intends to connect to an earlier charge of an over 80, of driving within a BAC over 80, all preconditions of that earlier charge are imported in the use of the evidentiary shortcut. So these two are fundamentally linked in a way that other sections are not.
Counsel, when you talk about reading the provision so that it has lawful within the provision, a lawful demand, part of a lawful demand would mean that there are reasonable and probable grounds formed by the peace officer. Reasonable and probable grounds, there's a subjective and an objective component to that. How do we determine what lawful means? Reasonable and probable grounds isn't defined within that section.
Yes, Your Honor, we agree that reasonable and probable grounds, in fact, are subject to interpretation. I have two answers to that. Firstly, in the case at bar, both the appellant judge and the judge at the trial division did in fact state without a doubt that the police officer did not have a lawful demand in his approach to Mr. Alex to provide a breath sample. And furthermore, as reasonable demand is not just a statutory requirement of this section, but as stated in the case of Burnshaw, a cornerstone of the charter, a precondition to every single interaction between citizen and state, it is our submission that it would be well within the trial judge's authority to subjectively interpret individual cases on hand to determine whether or not that burden of proof was met. Your Honor, the court must perform a statutory interpretation that is supported by the charter. It is our submission that the position advanced by the dissent and the majority, the position advocated for by our friends, presumably, and the majority, advocates for an interpretation that is not supported by the charter, but rather corrected by it. And it is our submission that this would have dangerous effects on both policy and application and the principles of the law.
Counsel, earlier you said that the legislator didn't want to be redundant, didn't want to put words in that are not unnecessary. Aren't you asking this court to conduct a redundant exercise? For example, under Section 8, we would consider whether or not to admit the evidence. And if we followed the scheme that you're recommending we follow, aren't we conducting the same redundant exercise?
Respectfully, Your Honor, this would not count as a redundant exercise. The presumption of reasonable grounds in Section 8 does not mean that the lawfulness of the demand is tested in every single case where the shortcuts apply. It will only be called into question should the accused in question have the resources to raise a Section 8 violation. What we are asking is to import lawfulness as a statutory precondition to the use of Section 258, which means that when the Crown is moving forward with a shortcut, that is when the lawfulness should be an additional precondition in addition to the rest that are already met. So therefore, it would not be redundant under Section 8.
But if your client is, let's say, not successful with this argument of lawfulness, could it still bring a Section 8 charter challenge?
Yes, Your Honor.
And you don't see that being possibly redundant?
Your Honor, perhaps it would be redundant, but consider the fact that these two situations have different remedies. If the accused wished to seek, if the accused wished to follow the statutory route and the judge were to rule that the demand was unlawful, the ensuing result would be that the shortcut is removed and the defense achieves the ability to cross-examine the witnesses, the toxicologist and the technician. After conducting such cross-examination, if they find that the unreasonableness of the initial demand still constituted a violation, then they could proceed with the Charter 8 claim. And this remedy would result possibly in the exclusion of the evidence and would also allow the Crown to weigh in on whether or not that demand was reasonably made. Thank you, Your Honor. Yes.
Counsel, you are saying that lawfulness is included in the interpretation of Section 258. But don't you think that if it was so crucial, it would have been expressly mentioned in this section and it wouldn't have been written as pursuant to?
Yes, Your Honor, but as I've stated earlier, since Section 258 is fundamentally linked to Section 254.3, 258 cannot take place if the charge for 253 hasn't been placed already. We would submit that the pursuant to a demand is enough to sufficiently import all conditions. Furthermore, the wording under Section 258 does not list the other preconditions of Section 254.3, but the Crown still has to abide by those. Therefore, we would submit that in this case, pursuant to a demand is enough. Your Honor, the majority raises a concern that our position could in fact cause unreasonable delays. It is our submission that this is not the case. Let's consider a charge over 80. This is a very common case heard at the trial division. Most of these cases are in fact resolved within a few days. The calling on of the additional testimony by a technician and a toxicologist would not pose such an unreasonable delay. Furthermore, in the case of Jordan, presumptive ceilings for delay were in fact firmly established of 18 months and 30 months for minor and more serious cases. Surely a few days additional to a case that is already very short is nowhere in near of reaching those delays laid out in Jordan. Therefore, this would not constitute unreasonable, and this would no way threaten Section 11 rights, the right to a trial within a reasonable time.
Counsel, Jordan deals with the 18-month ceiling and the 30-month ceiling, and it's applicable to all cases. There are a number of accused that go through the system, and while I understand that you're looking at it on a case-by-case basis in the submission that you've just made, one must recognize that it's not just about the 2 or 3 days that it takes a trial to occur, but it also takes into account the scheduling. So now you need to have a breath technician, but also a toxicologist from the Center of Forensic Sciences to come and testify. So we don't have an infinite number of toxicologists in the province. How do you reconcile the fact that you're saying it takes 2 or 3 days, but there's also a scheduling issue, and that will push back other cases that need to be within the 18-month presumptive ceiling?
Thank you, Your Honor. Your Honor, it is my submission that certain delays are in fact inevitable. In the case of importing the additional testimonies of the witnesses and calling them to the stand, yes, scheduling delays will be inevitable. However, it is not a question of which situation best avoids delay, but rather comparing the two to see which one posed a least inconvenience on the court system and the accused. In the case that you mentioned, the delays would be caused by scheduling that could vary amidst jurisdictions, but will not be the case for all. But rather in the case advanced by the majority, in the situation advanced by the majority through the charter violation, a Section 8 claim and a Section 24(2) claim will, without a doubt, result in delay, as this was called for a stopping of proceedings of voir dire, testimony from the Crown, testimony from the defense, a judge's deliberation to see who was right, and perhaps in that case, if the defense was right, they might also choose to additionally cross-examine those witnesses in question. So on one hand, we have an inevitable delay, and on the other hand, we have a delay that could occur. Therefore, it is our submission that our position would cause the least problematic delay for all parties involved. Now, Your Honors, I see that my time has in fact elapsed. If I could just take a minute to conclude.
Yes, please conclude.
Your Honor, it is our submission that in Rilling, a modern approach to statutory interpretation did not take place. In properly evaluating all of the terms written in the text plainly and purposively and balancing Parliament's intentions, it is very clear that the precondition of lawfulness must be established to move forward with an evidentiary shortcut. As such, we ask that this court allow the appeal, overturn the decision of the lower court, and remit this case to a retrial. Barring any further questions, this concludes the appellant submissions.
Yes, thank you very much.
Thank you.
And for the respondents?
Good afternoon, Honorable Justices of the Supreme Court of Osgoode Hall today. My name is Dhushiyanthan, initial N, and to my left is my colleague, Garofalo, initial R, and we are present today on behalf of the respondent, Crown, in the case at bar. It is the respondent's position that the Supreme Court of Canada correctly ruled that Section 258, subsection 1, and the provisions that follow, does not require a lawful demand when using the evidentiary shortcuts. The respondent is respectfully requesting that Your Honours dismiss the appeal and uphold the lower court's conviction. The respondent here today has 4 submissions to present. Our first submission, in accordance with statutory interpretation, is that Section 258, subsection 1, both paragraphs C and G, does not require a lawful demand under Section 254, subsection 3 of the Criminal Code of Canada. Our second submission, in accordance with public policy consideration, is that having to needlessly bring in 2 additional witnesses would overburden our criminal justice system, as supported by the 2016 Supreme Court of Canada decision of Regina and Jordan. Our third submission is that the 1976 Supreme Court of Canada decision of Regina and Rilling is good and binding law. However, it is irrelevant in the case at bar. Our fourth and final submission is that the Canadian Charter of Rights and Freedoms, supported by Section 8, followed by Section 24, subsection 2, provides an adequate remedy against unlawful search and seizure. I'll be addressing the first 2 submissions today, and my colleague the latter 2. To begin with the respondent's first submission in accordance with statutory interpretation, our friends today have submitted that pursuant to a demand refers to a lawful demand. However, Your Honours, Mr. Alex's interpretation of the law calls for fragmented preconditions that does not conform to the basic structures of the provisions in itself. If Parliament intended to specify that pursuant to demand be a lawful one, they could have easily done so, as they have done so previously time and time again in the Criminal Code of Canada. For instance, in Section 127, subsection 1, and I quote, "Everyone who, without lawful excuse, disobeys a lawful order made by a court of justice," so on and so forth.
But your friends were saying that that section of itself doesn't connect another section. So their argument was, when it doesn't say pursuant to, you don't need the unlawful, or you don't need the lawful language in there. And the section you're reading, it doesn't connect it to another section, correct?
Yes, Your Honor. However, the respondent is submitting today that pursuant to a demand refers to the 1969 initial enactment that speaks to bodily provisions, such as blood, urine, or breath. In the case at bar, it speaks to a breath sample that is received by Constable Caruso from Mr. Alex on the night of the alleged offense. Furthermore, our friends today have cited Bell Express 2002 Supreme Court of Canada decision of Bell Express U Limited and Rex. And I quote, "It requires the words of the provisions be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the Act, the object of the Act, and the intention of Parliament." Your Honours, Parliament's intent is to streamline drinking and driving proceedings, and that is why the evidentiary shortcuts were created. They speak to the timing, the method, and the qualified technician, to which the reliability of evidence is not within question in the case at bar. Furthermore, the Crown does not need to establish the lawfulness of the Brett demand for the evidentiary shortcuts that are placed in Section 258, subsection 1, with paragraph C and G.
Well, counsel, I think what your friends were saying, I don't think their position is that the reliability of the breathalyzer isn't in question. I think their argument is it could be in question. If we were able to put a toxicologist and a breath certificate analyst up on the stand, maybe we'd find some really good stuff to put this breathalyzer into question. What do you have to say to that submission?
Your Honors, in Section 258, subsection 1, both paragraph C and G, there are two inferences. For instance, the presumption of accuracy and the presumption of identity. The presumption of accuracy is that the breath certificate accurate measures of the accused's blood alcohol concentration. This prevents the Crown from having to needlessly bring in a qualified technician. And the presumption of identity provides that the breath test results also identify the accused's blood alcohol concentration at the time of the alleged offense. This prevents the Crown from having to needlessly bring in a toxicologist. This brings the respondent to their second submission in accordance with public policy consideration, as supported by the 2016 Supreme Court of Canada decision of Regina and Jordan. Your Honors, in paragraph 20 of Regina and Jordan, it states that liberty, security of person, and a fair trial is necessary. Liberty is engaged because a timely trial means that an accused person will spend as little time as possible held in pre-trial custody. Furthermore, fair trial interests are affected because the longer a trial is delayed, the more likely it is to faded memories, unavailability of witnesses, or lost or degraded evidence.
Counsel, when we talk about delay, you'll probably say, it takes some time to schedule a toxicologist, it takes some time to schedule a breath technician. But what about the delay that an accused person has to bring a charter application, has to cross-examine an investigating officer on, I imagine, a blended voir dire with the trial proper, then the accused now has to take the stand and testify in the voir dire, talking about the Section 8 issue, and then there's submissions from both Crown Counsel and Defense Counsel outside of the trial proper on the charter issue of Section 8. Doesn't that also feed into the delay? I mean, doesn't the fact that we already have a lawful demand imputed into that provision streamline the process in the long run?
Yes, Your Honor, which is why the evidentiary shortcuts were created. It protects the Crown from having to needlessly bring in 2 additional witnesses, which would only over-delay trial proceedings in an already overburdened criminal justice system, as 1-day trials would become 2-day trials, and 2-day trials would become 3-day trials, and so on and so forth.
Counsel, in creating the shortcut, Parliament was balancing efficiency versus an accused's procedural rights. Shouldn't the Crown lose the benefit of the balancing act when there's an unlawful demand made? Doesn't that tip it over the line?
If I understood your question correctly, Your Honor, you're asking the respondent here today that it's our obligation to ensure it should be a lawful demand?
Yes.
Respectfully,
beyond a lawful demand, what I'm saying is it's a balancing act. On the one hand, we have efficiency, we have the shortcut, but on the other hand, we have the procedural rights of the accused. And when there's an unlawful demand, we also have the efficiency argument, which you've been making all along. So it's a balancing act. Don't you lose the benefit of the doubt once it becomes unlawful? Isn't that serious enough that the rights of the accused become more important than efficiency?
respectfully, Your Honor, the respondent is not submitting today that the rights of the accused is much more higher than the Crown's position or Constable Caruso in itself. The respondent is submitting today that if the appellant found that his rights were infringed upon, the appropriate measure would be to file for a charter violation. Furthermore, the evidentiary shortcuts were created to streamline drinking and driving proceedings.
But just adding to my Chief Justice's comment, in this case, we have a situation where the layperson is not able to deny the demand. he must comply with this demand, or that in and of itself is another crime. So that person doesn't have the ability, or may not even have the understanding, to determine if it's lawful. They have to comply. So then, again, as the Chief Justice indicated, doesn't then the onus fall on the courts to ensure that an accused person, especially given the tenets of innocent until proven guilty, that their procedural rights are protected?
Your Honors, it is the respondent's position that the onus is on us under Section 11, subsection B, to provide a fair trial supported by Regina and Jordan. However, Your Honors, in the case at bar, Mr. Alex had voluntarily got out of the car and voluntarily provided the breathalyzer demand test, to which he had complied from Constable Cruz on the night of the alleged offense.
But I submit to you it wasn't voluntary. Once the demand is made, does he not have to comply, or fear of repercussions for failing to comply?
Respectfully, Your Honor, before I answer your question, I see that I'm running low on time. May I ask?
You have another minute to answer the question. Go ahead, counsel.
Thank you, Your Honors.
Would you like us to rephrase the question for you?
Yes, please.
Perhaps my friend can rephrase her question for you again.
My question is, I heard you say that Mr. Alex in this case voluntarily provided the breath sample test. And I submit to you that it wasn't voluntary, because the code sets out another charge if somebody refuses to provide a breath sample. That is, aside from whether you're going to be charged with over 80, you're not allowed to refuse. So therefore, the everyday person who's stopped and a demand is made of them, they must comply or face further charges. So then, doesn't the onus shift then onto the Crown? If we are going to make it a crime for somebody to refuse to provide a sample, doesn't that onus shift to the Crown to make sure that demand was lawful? And if it wasn't lawful, why does the Crown get the benefit of these shortcuts? Or why should the Crown get the benefit of these shortcuts?
To answer your question, Your Honor, though the onus is on the Crown to ensure that there is a fair trial or a timely trial, the onus is on the appellant as well to file a charter violation when they find that their infringements of their charter rights are taken into consideration. Furthermore, the shortcuts were created by Parliament to streamline drinking and driving offenses. As our friends have submitted today, and I quote, that there were several different cases in which drinking and driving proceedings could take into consideration, and that it is a serious crime.
You can conclude now, with a final comment. Go ahead.
Yes, Your Honor. Your Honors, to conclude, under the 1994 Supreme Court of Canada decision of Regina and Burnshaw, 4,100,000 individuals have died in traffic accidents in Canada. A further 2.5 million people were injured. These figures include drivers, passengers, cyclists, and pedestrians. They include mothers, fathers, and children. They include lives. Your Honors, it is within your discretion to take into consideration that it is not the respondent's position to infringe upon anyone's rights. In fact, it is quite the opposite of that. Constable Caruso, as a peace officer under the law, had an obligation to ensure that all individuals were protected on the night of the alleged offense. This includes Mr. Alex himself. Barring any further questions, Your Honors, this concludes the first two submissions on behalf of the respondent, and my colleague will be addressing the latter two.
Thank you very much.
Thank you, Your Honors.
Counsel?
Good afternoon, Honorable Justices of the Court. My name is Garofalo, initial R, and I will be delivering the final two submissions on behalf of the respondent, Crown, in the case at bar. The first of which is that while the 1976 Supreme Court of Canada decision of Regina and Rilling remains good law, it is irrelevant to the case at bar. The final submission on behalf of the respondent is that the Canadian Charter of Rights and Freedoms provides the appropriate remedy against unreasonable search and seizure. I will now begin with the third submission on behalf of the respondent. Your Honor, Regina and Rilling stands as good law because it has never been explicitly overruled. However, our friends have submitted that it is pre-charter. And while the respondent concedes to the fact that yes, Regina and Rilling is pre-charter, that does not make it bad law. In the case of Regina and Rilling, there was no charter to which an individual could apply to Section 8 or a Section 24 subsection 2 remedy.
But counsel, isn't Rilling bad law then? Let's think about this for a second. It predates the charter. The charter comes into play in 1982. Fast forward to 2018, we're sitting here today, and what you were suggesting is that, and this is your fourth submission, but what you're suggesting is that Mr. Alex has resort to Section 8 and Section 24.2 of the charter. Imagine Mr. Counsel does not have a lawyer. Imagine Mr. Alex is a self-representative accused, which we see quite a bit in the court system. And now what we have effectively done is made Mr. Alex to be in a position where he needs to bring the charter violation application. So he needs to recognize that his Section 8 issues were violated, and then a 24.2 analysis has to be made. Versus if we impute lawful demand into the section, into the provision, then the onus is always on the Crown to prove that the demand was lawful. Isn't that the more appropriate way, and isn't that the reason why Rilling is now bad law?
Your Honor, I'll answer your question in two parts. To start, to reinforce my colleague's statutory interpretation that a demand need not be deemed lawful in order for the evidentiary shortcuts to apply. As explained by my colleague, Parliament could have intended, they could have simply explicitly stated a lawful demand as they have in Section 127, subsection 1. Furthermore, the pursuant to is in reference to a breath sample, as in 1969 there were other bodily samples. And Your Honor, should this court accept that a demand need to be lawful in order for the evidentiary shortcuts to apply, then the appellant would have had to file a charter application. In accordance with the 1987 Supreme Court of Canada decision of Regina and Collins, and further established in the 2009 Supreme Court of Canada decision of Regina and Shepherd, the onus is indeed on the appellant to file a charter application. Furthermore, Section 24, subsection 2 of the Canadian Charter of Rights and Freedoms is not a remedy for police misconduct. Your Honors, the respondent concedes to the fact that this court does have the authority to dismiss evidence should it bring the administration of justice into disrepute. However, Section 24, subsection 2 is not a remedy for police misconduct. Just because a right was violated does not mean necessarily that the evidence will be dismissed.
Counsel, I have a question. So if, imagine someone has to take his breath under this test and is arrested, is obliged to do it but refuses to do it. And then he's still arrested and interrogated by the police, and then he could claim the Constitution, Section 8 say it's an unreasonable search and seizure, but they wouldn't have the proof that, as he wouldn't have taken the test, they wouldn't have the proof that he had or not alcohol in his body. Whereas someone who is arrested and does the test could not really have all the same resources as this person, because it means that if lawfulness or unlawfulness is not a criteria, then someone who chooses to refuse to take this test and who indeed was above the range that he could for the test, then could use the charter and get away with it. Whereas someone who does what the police ask of him and the demand was unlawful would then not have the same rights as the other person. So wouldn't unlawfulness or lawfulness of the demand be actually a decisive criteria in order to have the proper administration of justice?
Your Honor, whether or not a demand is lawful does affect the administration of justice. However, Section 258 deals solely with reliability of evidence. It deals with streamlining court proceedings. Should a demand not be lawful, the appellant has two options. One, in accordance with Section 254, subsection 5 of the Criminal Code, should they have reasonable excuse, they can refuse the demand. However, if they choose not to, and the demand is deemed to be unlawful at court, the onus is on the appellant to bring forth a charter application. However, the court can dismiss the evidence should it bring the administration of justice into disrepute. To quote paragraph 43 in the Supreme Court of Canada decision of Regina and Collins, the charter is designed to protect the accused from the majority. So the enforcement of the charter must not be left to that majority. Your Honors, to touch upon public policy, as explained by my colleague, yes, it is the Crown's constitutional obligation to ensure a timely trial, and the respondent is not submitting that we do otherwise. The respondent is submitting, however, that based off the statutory interpretation put forth by the respondent, a demand need not be deemed lawful before the evidentiary shortcuts apply. So with this in mind, should the Crown have to call upon two additional witnesses who do not even speak to the lawfulness of the demand, it would unnecessarily extend trial proceedings.
Counsel, isn't it more important from a public policy perspective that we set standards for the police to make lawful demands than the expedience of a hearing?
Your Honor, the respondent agrees that it is important to make sure that police are complying with the law and are making lawful demands. However, the question at bar is whether a demand has to be lawful for the evidentiary shortcuts to apply. And the evidentiary shortcuts refer to reliability of evidence. Whether or not an officer makes a lawful demand is controlled by the charter itself, not by Section 258 of the Criminal Code.
Then how is it controlled by the charter? Because the charter is a different, offers remedies for violations of it, but it means that then someone who is the object of an unlawful demand has to know the charter, claim the charter. Isn't it given the green light to the police to do what they want, and if they get caught, they get caught?
Your Honor, while police officers must act in accordance with the charter, the respondent concedes to the fact that yes, there are times, such as in the case of bar, when an officer makes an unlawful demand. However, in those cases, there are two options. Either the appellant must put forth a charter application, or the court does have the authority to dismiss the evidence should it bring the administration of justice into disrepute. But the respondent submits that admitting the evidence in the case of bar does not bring the administration of justice into disrepute.
You've indicated, counsel, that you don't think that this is an attack on the reliability of the breathalyzer device and all the rest. I'm inclined to agree with you. The breathalyzers themselves are quite reliable. But your friends have submitted, and I share their concern, that perhaps the agents who are administering the breathalyzer may not, and I'll certainly give you time to answer that question, the individuals administering that breathalyzer, not the police officer, but the breath technician, who now will not be called to testify under your rubric, may not be reliable. And in fact, says your friends, the state and its agents have already acted contrary to law by administering an unlawful breath test. Therefore, we should bring all of the agents of the state in for questioning into the courtroom so they can be subjected to cross-examination. Is the reliability of the breathalyzer now under attack because the agents of the state have indicated they act contrary to law?
Your Honor, as you have stated, the reliability of breathalyzer demands is now well established as per the Supreme Court of Canada decision of Saint-Ange-Lamoureux. However, the breath certificate and the two additional witnesses both speak to the same things. They speak to the presumption of accuracy and the presumption of identity. Bringing in these additional two witnesses would be unnecessary, as the scientific reliability of evidence has already been established. Furthermore, The 2 additional witnesses would have to be on call at all times because there is a fine line between reasonable and unreasonable grounds. It is unknown before the pretrial whether or not those will be present. May I briefly conclude, Your Honors?
Yes, you may. Go ahead.
Your Honors, we cannot provide the appellant with every form of hollow defense against what he did do that night. Mr. Alex drove impaired. He did not file a charter application. However, Your Honors, the respondent submits that whether or not a Section 8 charter violation was filed, the administration of justice, should the evidence continue to be admitted, would not bring the administration of justice into disrepute. Your Honors, for the reasons submitted by both myself and my colleague, the respondent respectfully requests that this court dismiss the appeal and uphold the lower court's conviction. Barring any further questions, Your Honors, that concludes the submissions on behalf of the respondent, Crown. Thank you.
Yes, thank you very much, and thank you to all counsel. The judges are now going to adjourn, and we're going to come back in about 10 to 15 minutes. Thank you.
All rise.
And I can tell you, we debated in the back as to which team was better, and it wasn't a unanimous decision. It was a split decision here. It was really, really close in what we had. And, tonight's the Academy Awards. I'm not going to mess up like they did in the Academy Awards last year. So I wrote down, who won the Osgoode Cup, and I congratulate the appellants for winning the Osgoode Cup.
This now concludes the 2018 Osgoode Cup. Thank you so much.